House of Representatives just passed a bill that may not sound flashy, but could meaningfully affect how long veterans wait for decisions on their VA appeals. It is called the Veterans Law Judge Experience Act, and it focuses on one core idea: decision quality matters. Specifically, this bill aims to reduce delays at the Board of Veterans' Appeals by prioritizing the hiring of veterans law judges who already have experience in veterans law. To understand why that matters, it helps to start with what veterans law judges actually do. VLJs, or veterans law judges, decide appeals when a veteran disagrees with a VA decision. These cases can involve disability ratings, effective dates, or denials of service connection. Each appeal requires a VLJ to apply complex statutes, VA regulations, medical evidence, and binding case law from courts like the Court of Appeals for veterans claims. Veterans law is highly specialized. It is not intuitive, and it is not something most attorneys know automatically. In my time as a veterans law judge, I saw that experience shows up in the decision product: issue framing, evidence analysis, and whether the decision holds up without avoidable rework and remands. That is why, for many years, VLJs hired to the board were required to have meaningful experience in this area of law. That requirement was removed in 2020. Since then, the board has hired VLJs who may be talented attorneys, but who were sometimes brand new to veterans law. The Veterans Law Judge Experience Act responds directly to that change. The bill, which has passed the House of Representatives by voice vote, would give hiring preference to candidates with at least 3 years of relevant veterans law experience. In plain English, it says that experience in this field should matter again. Now, why does this matter so much to veterans? It's because many of the longest delays in the appeal system are driven by remands. A remand happens when a decision is legally or factually flawed and has to be sent back for more development and another decision. Each remand can add months or even years to a case. Veterans don't experience delay as a statistic. They experience it as carrying costs. They are waiting for back pay and monthly compensation. Many are unable to work or are dealing with serious health conditions while their case cycles through the system again and again. A system built on rework cannot sustainably move faster. First pass decision quality is the long-term speed strategy. That's the logic behind this bill. Veteran service organizations and employee unions that work closely with the appeal system have strongly supported this legislation. Disabled American Veterans has described it as a common-sense fix that reduces ramp-up time, improves consistency, and increases the likelihood that decisions will hold up without avoidable remands. The American Federation of Government Employees has also warned about what happens internally when experience requirements are lowered. When VLJs are new to veterans law, attorneys and staff spend significant time training decision makers instead of moving cases. Experienced employees are pulled off production, morale suffers, and retention becomes harder. One retired VLJ described veterans law as, quote, far more complicated than the tax code. Think about that. There's also an important structural point here. Veterans law judges are not only decision writers, they mentor attorneys and help set legal standards within the board. When VLJs are learning the field from scratch, training can become upside down, consistency suffers, and error-driven remands increase. From the veteran's perspective, the impact is simple. When decisions are inconsistent or legally unstable, the veteran pays the price. However, it's important to be clear about what this bill does and does not do. It does not limit a veteran's right to appeal, or reduce access to hearings, or restrict evidence. It does not guarantee faster decisions overnight. What it does is target decision quality at the VLJ level with the goal of fewer errors, fewer remands, and more durable decisions the first time. You don't get durable throughput from a system built on rework. You get it from first pass quality and fewer avoidable remands. Right now, the bill has passed the House and will move to the Senate for consideration. Whether or not it becomes law, it reflects a growing recognition in Congress that veterans law is specialized and that experience is not optional when veterans are waiting years for answers. This is not a partisan concept. It is a competence concept. Veterans deserve decision makers who already understand veterans law. For veterans currently in the appeals process, the practical takeaway is this. Even if this bill becomes law, appeals will still be complex and will still take time. Submitting strong evidence, responding to VA requests, and understanding appeal options remains critical. At the same time, legislation like this signals that lawmakers are paying attention to systemic causes of delay, not just surface-level metrics. If you want to learn more about the Board of Veterans' Appeals procedures, appeals timelines, or your rights, educational resources like CCK Law's blog and videos are available to help explain these issues in plain English. Thank you for your time, and thank you for listening.